In terms of the espionage charges, I think that they're just as threatening to national security reporting as the aiding the enemy charges against Manning. And unfortunately, the press hasn't been here to cover this trial, so they sort of forgot about the espionage charges while they focused on aiding the enemy when they came to the trial lately. I'm not sure if you can hear me.
Yes, we can hear you, Alexa. Go ahead.
Sorry. One of the other interesting things is that she actually found Manning guilty of stealing 5 databases. Now, what's controversial about this sort of set of charges is that she allowed the prosecution to actually change the charge sheet after the close of evidence. And the defense had actually sought to dismiss these charges, saying that the government hadn't presented any evidence related to the theft of databases. They had merely presented evidence related to the theft of information. And according to federal statute and controlling law, there's a distinction between databases and the information contained within. Well, Lind came back and said that there was no distinction between these two denominations or categories of theft. And she allowed the government to change their charge sheet. The defense filed another motion, and you can expect to see that in the appeals process. And then we have the Computer Fraud and Abuse Act charge. Here, Manning had access. He was given a link to the net-centric diplomacy database in January of 2010 by the highest ranking intelligence officer in the T-SCIF. So he had access. He didn't violate any technical breach to get the information. What seems to be happening here is Judge Lind is really coming down hard on the idea that if it's classified and he leaks it, then it's espionage. We need to remember, this trial has been about probable harm. There's been no actual harm actually on the merits. Now that we're in the sentencing phase and Manning faces 136 years, we can actually start to talk about the lack of actual damage from these leaks. And that's what we're doing today. So since the court ruled that motive and actual damage or lack of damage evidence was not relevant at trial, essentially here we enter the sentencing phase where these two concepts can be discussed. Whether or not there was any damage from these releases and what Manning's motive was. And what we're going to see happen is the government is going to bring out 13 witnesses in closed sessions or with classified stipulations, so under black redactions, to talk about the lack of damage from these leaks. And why do I keep saying lack of damage? Because in the pretrial record and in public reporting, we know, for example, that Brigadier General Robert Carr, who was the head of the Defense Intelligence Agency's Information Review Task Force, determined that there were no sources and methods in these in the Afghan war logs or the Afghan war diary or the Iraq war logs. Robert Gates wrote a letter to Senator Levin in August of 2010 telling him as much. And that letter is part of the court record. We also know that the Department of State has another classified damage assessment. What's interesting from the pretrial record of 3 State Department witnesses is, and also public reporting, is that Kennedy was responsible for testifying to Congress back in December of 2010 and early 2011. And 2 congressional officials, anonymous congressional officials, congressional aides told Reuters that the State Department was, that the impact of the revelations was embarrassing but not damaging. And then there's another classified damage assessment from the National Counterintelligence Executive, which is part of the Office of the Director of National Intelligence, headed by Clapper. And this was really a mitigation team set up in every federal agency, and it's headed by a newly established national security staff insider threat group, headed by Clapper at ODNI and Eric Holder at the Department of Justice. And this was recently reported about by McClatchy, these insider threat groups within the federal government. So it's going to be a very, very interesting time. We'll also have unit witnesses. The question, of course, remains is how much of this part of the trial, the heart of, the trial in many cases, to try to knock down this 136 years, the public will have access to.
Alexa O'Brien, one of the charges for which Bradley Manning was found guilty was what they called wanton publication. Could you explain the significance of this, especially with respect to military law and with regard to WikiLeaks?
Absolutely. So wanton publication, Manning was found guilty of. He faces 2 years maximum for it. Now, this particular offense has never been used in a military court-martial before. It's not tied to any existing federal violation or punitive article under the Uniform Code of Military Justice. Now, what's interesting about this is oftentimes whatever witnesses testified for aiding the enemy also testified for wanton publication. And what the government, essentially their case, what it was based on, wanton publication, the release of large data sets, was essentially that WikiLeaks was not a legitimate journalistic organization. That was one of their sort of theories that propped this up. And the other one was that evidence about receipt by the enemy of intelligence could be used to show that Manning's leaks were wanton. So this is meant to prescribe disclosures of large data sets that that are made available by the internet. It's very cheap for people to publish right now. And while Manning doesn't have to be the proximate publisher, it certainly is a chill or prohibition against anyone who in the military or in the national security arena who wants to publish something on the internet that will make the government angry.